Welcome to those of you who have joined us early. We'll just wait another couple of minutes while people get on board. Welcome to those of you joining us now. We're just going to wait a couple of minutes to make sure we get everybody online. Just one more minute, everyone, and then we'll kick off. Tēnā koutou katoa, ko Emily Grace Toku Ingoa, and I am NZPI's Principal Policy Advisor. It's my pleasure to kick off this webinar, a joint one between NZPI and RMLA on the Fast Track Approvals Bill. We've still got a few people rolling in, but they won't miss too much, so we'll get going. There's lots to talk about. I'm joined by three presenters today from NZPI and RMLA. I'm joined by Gina Sweetman, NZPI Fellow, Helen Andrews, Director at the Environmental Lawyers, and Doug Fairgray, a Director at Market Economics. So thank you very much to my fellow panellists. Just a general disclaimer to start with that I'm sure for people in the audience, it's possible that we've been involved in particular projects that might be ending up on this fast track process, but The points of view that you will hear today are focused on the bill and the Select Committee recommendations and aren't kind of project-specific ones. And just one other disclaimer, Gina is NZPI's chief, I've forgotten her title. I'm sorry, Gina, I should have written it down. Anyway, Gina's been doing super awesome work in at MFA on behalf of NZPI, including related to the fast track process, but she's not sharing any of that information with you today either. So with those kind of bumbly things out of the way, we are going to sorry, I'm just getting my slides to go across. Here we go. So structure for the webinar today, I will provide an overview of the changes and some of what stayed the same. I'll make a few very brief comments about NZPI submission points relevant to those. Helen is going to talk about the treatment of the RMLA submission and what we see in the bill now, as well as discuss the list of projects. So that's our kind of what's changed from what we saw to start with. And then we're going to have Gina provide some comments from a commissioner's perspective. So what does this all mean from a commissioner's perspective? And Doug is going to talk about the kind of economy and logistical sort of implications of the system getting up and running. So I will kick off with an overview of the changes. Now, just to start with, and very briefly, we're not at the end of the legislative process for this bill yet, so I just wanted to be clear that what we see at this point in time isn't the end version. So we're talking about the Select Committee report and what the recommendations are in this for the Select Committee to the government to amend the bill. There's still a second reading, Committee of the Whole House, and the third reading and Royal Assent to come. So there's chances the bill might change a little bit more. And we actually know for sure that it will change in one particular way, in that the list of projects that there's been a lot of media attention about, that's not actually in the bill yet. And Helen will talk a little bit more about this. That process of identifying projects has been run by the Minister with the Fast Track Advisory Group, and it's happened outside of this legislative process. So if you look at the bill online at the moment, you will still see an empty Schedule 2. We don't expect that to be introduced to the bill until maybe the third reading. So just keep that in mind as we go through. So an overview of the fast track process. This is a slide that I used back in March when I did an explanation of what the bill was as introduced, and it's quite useful to see what's different now. So I've already mentioned about, no, I haven't quite mentioned it yet, the Schedule 2 projects. It's not a change in the bill yet, but the government has announced there'll just be one list of projects and not two. So you'll see an X at the top. There are going to be two ways into the fast track process. There were previously going to be three. So if a project is listed in Schedule 2, it bypasses the referral stage, and those projects can make applications directly to the EPA to go through an expert panel process. There is also an ability, once the bill becomes law, for an application to be made for referral, and that application is considered by the Minister for Infrastructure about whether that project would be referred into the fast track system. Now, that's one of the key changes the Select Committee has recommended. Previously, as the bill was introduced, it was the joint ministers that would do decision making under the bill, and that was the Ministers for Infrastructure and Transport and Regional Development. The Select Committee's recommendation is it's just the Minister for Infrastructure that will make that decision. So two ways to kind of make it into the fast track process there. And then another quite significant change that the government announced kind of before the Select Committee got round to recommending it in their report. But expert panels will now make decisions on the approval applications. So under the bill as introduced, the joint ministers, those three ministers of infrastructure, transport and regional development, would make decisions on whether to grant or decline approvals kind of on the recommendation of the expert panel, but the NZPI submission and many other submissions highlighted that there was an awful lot of ministerial power focused at that point, and the expert panel process kind of seemed a little bit pointless given the way that was all kind of set up. And so the recommendation now is that the joint ministers don't have anything to do with the substantive decision making, and instead expert panels themselves will actually make the decisions. So from NZPI's point of view, that's a good change to have seen come through. So just to provide a little bit more detail on the referral process, that kind of step one, the way into the fast track process if you're not a project listed in Schedule 2. This is where the eligibility criteria and the significant regional or national benefits pops up. So to be referred into the process, it needs to be infrastructure or development that would have significant regional or national benefits, and that list of regional and national benefits that was included in the bill as introduced is largely the same. So there were quite a lot of submission points, including by NZPI, that it was very wide and broad and loose criteria. Select Committee kind of notes that and then says that the intent of the bill is to provide an approvals pathway for a wide range of projects, and so they haven't changed the eligibility criteria. But there's still a very broad list of things that could be eligible for fast track, and they haven't done anything about the ability to apply for prohibited activities, for instance. So that still remains in the bill. There's another aspect to eligibility, which will be interesting to see how it kind of plays out, in that using the fast track process for a particular approval is supposed to enable a more timely and cost-efficient process than you might get outside of the fast track system, and it's not supposed to materially affect the efficient operation of the fast track process. So given there's already 149 projects on the list to use the system, it's interesting to see if there's projects that then come in and apply to use the process and how they might be considered. One of the key changes in the referral process was the one I mentioned earlier, excuse me, about the Minister for Infrastructure making decisions on this rather than joint ministers. But one thing that's been added, which NZPI is pleased to see, is that the Minister for Infrastructure must seek some written comments from the Minister for the Environment before making a referral decision. The Minister for the Environment was missing from the bill as introduced, and NZPI, along with lots of others, suggested there should be more of a role for the Minister for the Environment, so it's good to see that change brought in. A little bit more detail on the substantive decision making. So this is all the projects listed on Schedule 2 and anything that gets through the referral process subsequently. This is the decision making that the expert panel will do. The consideration that gets the most weight in that decision-making process is the purpose of the Fast Track Act, and that has been tweaked, although not in the way most of the submitters were wanting. So there's an absence of environment in the purpose, and there were a lot of submitters that suggested that should be included, including NZPI, but it's largely the same. So the purpose is to facilitate the delivery of infrastructure and development projects with significant regional or national benefits. So that gets the most weight when considering applications. And then all of the normal RMA decision-making considerations will also apply, except not Section 8, which is the treaty section, and not Section 104D, which is the non-complying gateway test. That hasn't changed. Those two bits were in place when the bill came out. Just in terms of the way the bill looks, previously the bill listed out the different considerations like national direction and RMA statements and plans. Those aren't listed out anymore, but those are the things you consider when you apply Section 104, for instance, under Part 6. Now, one of the key other changes that's worth a mention is there is a section now on when a panel can decline an application, and that includes if the adverse impacts are significantly sufficiently significant to outweigh the purpose of the Act. And that's quite a big deal change to see, because there were a lot of submissions about the environment not getting enough attention in this bill. And so there is now a potential where the purpose of the Act might not actually override everything. So there's an allowance here that applications could be declined if the adverse impacts are sufficiently significant to outweigh the purpose. So that's an interesting change to see. Okay, just quickly on expert panels. Expert panels now have decision-making power, and they didn't have that to start with, but there's not a lot of change otherwise to expert panels. There's still a maximum of 4 members, must be a lawyer or a planner as the chair, and 1 member must be appointed by relevant local authorities, and panels have the ability to appoint special and technical advisors. A couple of specific changes. The recommendation is to remove a requirement for 1 panel member to be nominated by the relevant iwi authorities, and the Select Committee says that's because the kind of next provision along also says that the panel arrangements have to reflect the decision-making arrangements that are in place through legislation or agreements like mana whakahuna orohi. So that's a change to think about. There's also been some tweaking to the skills and experience of panel members. The Te Ao Māori requirements have been broadened, but they have the word qualified in front of them. I'm not entirely sure what qualified would mean in that context. Environmental matters is now a requirement for the panel, and that wasn't there before. So that's a good thing to see. And my 2 minutes is just about done. So really quickly, there have also been some timeframe extensions in the bill. NZPI was concerned that timeframes were quite short for providing comments and for panel decisions and for all of those kind of things, along with other submitters, and those timeframes for participation have been extended. And I'll wrap up there. Most of these points will be picked up by other speakers. I am going to hand over to Helen.
Thank you, Emily. Kia ora koutou. Yes, ko Helen Andrews toko ingoa. One brief matter to cover off before I get into the substance, which is I think in terms of queries, using the Q&A function for that. If you do have questions, I think there's some coming through now, but if there's another route you want to use for that, then Emily will let people know.
Yeah, sorry, Helen, I did forget to say that. Yes, please use the Q&As and we'll come back to those at the end. Thank you.
Excellent, thanks. So yeah, I will just briefly cover firstly how the RMLA submission was addressed via the Select Committee report, and then this list of 149 projects we have to be added to Schedule 2 of the bill. So firstly, in terms of the RMLA submission, to briefly summarise, that submission did acknowledge the need to address increasing consenting timeframes and costs. That is accepted as being an issue across the board. Key concern, though, was the lack of environmental protection afforded by the bill, and whether that was justified in the circumstances. And it's not just that the environmental protection wasn't there, it's that it was very deliberately not there. And rather than looking to address key issues with the current consenting system at a systems level, and I've noted there what some of those are, particularly around council capacity in particular, and capability, the complexity of national direction and being able to deal with that through the consenting process, and the consistent and constant regulatory legislative change are all key factors in terms of contributing to consenting costs and timeframes currently. But rather than addressing those issues, the bill simply looks to override the current system by introducing another bespoke consenting pathway. So we'll go on to the next slide. What we've got there is just the list of headings under which we address the RMLA's key concerns with the bill. One in particular to focus on is the potential ability to actually achieve the outcome sought by the bill, i.e. a faster consenting process. And is the bill actually going to get there? There are issues in that regard, particularly in terms of the ability to appoint the number of panels required to address all the projects that have been identified. And in this context, there's even a question as to who would actually take on the role of panel convener to appoint all those panels. There is no time frame again for appointing panels, so that is can often be a significant delay in the system. And as the bill has been reported back from the Select Committee, the panel can now extend timeframes for their consideration of applications as the panel thinks fit. There's also, given the constitutional and other issues with the bill, and access or lack thereof to justice that it provides, the significant likelihood of challenge through the courts to both potentially the bill itself and projects that are consented by the process, as well as a key question around the financing available to implement all these projects. So if all the 149 projects, or the vast majority of them, were approved in short order, a lot of those involve government expenditure, and there's now a significant question of where all that expenditure would be coming from, and whether all the projects could actually be funded. It certainly was a challenging submission, given that the purpose of RMLA's input on these types of matters is generally to promote excellence in resource management policy and practice, and resource management processes which are legally sound, effective and efficient, and which produce high quality environmental outcomes. Now, obviously, commenting on a bill such as this, which, as I say, is deliberately designed to override and avoid a range of existing environmental protections, did present an interesting challenge. So on that basis, we did make comment as best as possible as to workability issues that we saw with the bill, and also made the point that what is really required is a bipartisan approach, or multi-partisan as it may be now, to resource management legislation, which is going to endure, as the RMA has done for 30 plus years now. We can't keep living in this circumstance where we have an ever evolving roundabout of legislation, and 180 million being spent on reforms, which are then immediately repealed when they're introduced, and losing that kind of resource and effort. So that was the key nature of the RMLA submission. In terms of the response to that, if we can have the next slide, please, Emily. There were 3 minor matters that were accepted. 2 of those around, as Emily's mentioned, the extension of timeframes for commenting on both the referral applications and substantive applications, both going from 10 to 20 working days, which still doesn't actually really leave sufficient time for the applications or invitations to comment to reach some of those parties that don't have emails, for example. Nevertheless, that extension has been made, and as Emily's noted, the decisions on applications are now made by the expert consenting panels, not ministers. Otherwise, there was very little change in response to any of the matters raised in the RMLA submission. And just a note on that, it may look from the Select Committee report that there were a range of changes made. There's lots of tracking and crossing out and additions, but 90+% of that is simply a reordering, a restructuring that the Select Committee thought was appropriate. Very little substantive change has been made, other than what was pre-announced on authorisation by Cabinet. So effectively, the Select Committees, or the majority of the Select Committee, have acted on the instructions that they received from Cabinet, and gone with that and nothing more. Certainly, as noted, the Select Committee report obviously is only supported by the majority, and there's commentary in there on from both the Labor and Greens perspective, which certainly makes interesting reading. So turning now to the list of projects. There were 384 projects that applied to be included in what was then Schedule A or 2B of the bill. And as I've noted there, effectively Schedule 2A was automatic referral. Schedule 2B was an interesting one. You were almost kind of acknowledged to have either regional or local benefits, national or regional benefits, but you hadn't quite convinced the ministers that you should be referred yet, so you got put on the list and still had to make a referral application. There was an advisory group appointed to consider all those applications, and they ended up recommending 199 of those 384 projects for inclusion in Schedule 2A and 143 for inclusion in Schedule 2B. So 42 of the projects that originally applied, other than those that withdrew, were not recommended for listing. And the advisory group did consider prioritisation of those projects as well. So for Schedule 2A projects, they ranked those 1 to 5, and for Schedule 2B, they gave them a high, medium or low ranking. Now, we are in the dark largely in the dark as to what criteria were used to apply that ranking. And the applications themselves are not, at least as far as we're aware, publicly available. So in terms of the criteria and process in the bill for referral applications for those 149 projects which have now been listed, that referral the process is already complete. So we can just move on to the next slide, please, Emily. Of those 199 plus 143 projects that were recommended for inclusion in the Schedule 2A and 2B of the bill, the Cabinet has selected 149 and announced that list on the 6th of October. As Emily's mentioned, those projects will be included in the bill at the Committee of the Whole House stage or later, so are not subject to public scrutiny. And I've just included there the breakdown of sectors that the projects relate to, and Doug's going to talk on that in some more detail as well. Again, the Cabinet decisions around how that list of 149 projects was chosen aren't publicly available, and nor has there been any indication of how those 149 projects are to be prioritised. As far as we're aware currently, that it's a free-for-all, so you just get your substantive application and hope that you get appointed and get underway with a panel to consider your projects. The other point to note is, as has been covered in the media, those 149 projects do include some such as Trans-Tasman Resources seabed mining that have previously been considered and rejected based on environmental grounds. While there was supposed to be Schedule 2A and 2B, the Cabinet has decided that all 149 projects should be included in Schedule 2A, so now there's no Schedule 2B. And certainly, as we've previously noted, it's very unclear how we're going to be able to resource 149 expert consenting panels straight off the bat. And with those few comments, I will now pass over to Gina.
Thanks, Helen. Kia ora tātou, ko Gina Sweetman toka ingoa. I'll be talking to you about a Commissioner's perspective. So things that I've observed in the Select Committee report from a Commissioner's perspective that I'm feeling a bit more comfortable about. As Emily has said, the ability of panels to extend timeframes for the release of decisions, because certainly as the bill was introduced, the timeframe was pretty tight. Certainly also support the ability to appoint special advisors and technical advisors to support the panels as well. And I'll come back to those points why I'm supportive of those shortly. And one thing I was definitely quite positive to see was the new ability to decline approvals where there's one or more adverse impacts, where those are demonstrated to be so significantly sufficient that they'd outweigh the purpose of the Act. That was certainly something I was concerned about in terms of, as a commissioner, as a panel member sitting on these, how would you do that balancing up where at the moment the bill says that the highest weighting, greatest weighting is given to the purpose of the bill, but then underneath that you still have to give consideration to the relevant provisions of each piece of legislation that approvals are sought for. And so the concern was, well, how would you weight those against each other? Would there be the situation where their adverse impacts were such that, it really shouldn't be granted? Next slide, Em. As Helen said, and Emily's already talked about as well, just the sheer availability of panels with suitable experience to deal with those 149 approvals, plus additional approvals that may be applied for in the future as well, is a concern of mine, particularly as we're also trying to continue with normal processes that are already underway, and then throw in a bit of resource management reform on top of that, and how we all going to manage. And the other thing is, yes, it's 149 approvals. It's not just resource management approvals. There's also an increased scope of what panel members will be considering. So it's not just the COVID fast track that we've been used to. It's all the Conservation Act, Reserve Act, Wildlife Act, Mining Act approvals. I don't have any experience in anything except really the RMA and a little bit of sprinkling of Conservation Act and Reserve Act. So trying to get commissioners with that breadth of experience, I think is going to be quite problematic. And potentially, well, that might be the role of the special advisors, is to bring in that expertise. So I guess we'll wait and see. Next slide, Emily. One thing, of course, very near and dear to my heart is, are we going to be paid enough? I know that this is an issue that NZPI, RMLA, a lot of others, our select committee, can ensure that panel members can be paid appropriately. At the moment, fast track panel members are paid in accordance with the cabinet fees framework, which is generally usually about half of what everyone else involved is getting paid, consultants and technical experts and the like. So, ensuring that we can get panel members remunerated appropriately for the complexity of the applications that they're going to be dealing with, I think is really important. And when I read what's on the screen, I can't decipher that. Emily? One thing that also, another thing that concerns me is just ensuring that whatever does get to the panels is sufficiently complete. On the fast track panels that I've sat on to date, there have been issues in terms of lack of completeness of the applications that have made their way through to the panels. So that is a concern. So you want to ensure that those government agencies who'll be doing the completeness tests, the EPA, are up to speed, that they're ready to hit the ground when these applications start coming through their door. And certainly that might require some upskilling and increased resourcing with agencies. And I see EPA having to play an increasingly significant project management role. Multiple reviews, multiple approvals, multiple agencies. And of course, those, because we don't have the local authorities as involved in that earlier stage, those parties need to have a good understanding of local plans. Emily? So things top of mind for me when I'm considering about these approvals that are going to be coming through is what happens when we get competing applications for the same resource that come through. So they might be the same land, the same natural resources, the same water, the same airspace, the same coastal space. How are those dealt with? Whether they're both fast track applications or one's fast track and one's on the normal system. How do we deal with that? How do we, particularly with the allowing prohibited activities through and the non-complying Section 104D test not being there, how are we going to deal with over allocated catchments if we get applications which are seeking those resources? What's the implication if there are consents in the system seeking reconsent and a fast track consent comes in? Those are the things that are concerning me. Infrastructure and strategic planning, how are we going to work these together if there might be significant new proposals? There's no infrastructure, the infrastructure's over capacity, there's a lot of investment. So that whole relationship between a proposal, council infrastructure, central government infrastructure, other infrastructure and the funding, I think is something that's, well, it is also concerning me. And will well-functioning urban environments still matter? Obviously, there'll be a consideration, but not as important as regional and national significant benefits. And then I just answered my own question. I look back at, I love these clause numbers, 24W, decisions on approval sought and substantive application, and clause 4 of that tells me that the panel may consider the extent of a project's regional or national benefits when undertaking its determination of an application. So I've answered my own question. If there is additional commentary that comes through from comments, the panel will be able to consider those. Emily, is that me? Yes, it is. So handing over to you, Doug.
Yeah, thanks, and thanks for those interesting comments. We do have a number of challenges facing us. If you can look at the first one, though, issue, what I've done is looked at the projects, provide an overview of those in terms of what it's like, putting them on the ground, basically, and then circling back from that to say, well, as I've seen, there's 4 potential issues. One is if there's high priority given to so-called favoured projects, is there a risk of playing favourites at the expense of other projects which may deliver more benefit? So there's a competitive aspect. Second issue is, we're all pushed for timing. Is the need for speed, might that mean a lesser standard being applied to project evaluation? And might there be sort of less scrutiny once a project qualifies to get on the fast track list? Emily, next slide. Yeah. Third issue, large volume of development may be put on the ground once it's approved. And will the resourcing constraints, which are already evident in the fast track consenting, will that translate through to the project development itself, not just the approvals and so on, but actually getting the work done? And related to that, will the focus on the fast track projects limit the resourcing and make other developments slower? So I've looked at the 149, and it's important to look at the list itself and the nature of those, because the nature of the projects and their distribution is going to have an important role in the effects of the projects and the effects of the fast tracking process. A very simple breakdown there. Apologies for the colours, my colourist is absent. But if you look at the distribution of the projects by region, the green ones are the housing and urban development, the grey ones are infrastructure, so the strong focus on both of those. and also we can see that the volume of projects is generally distributed according to the level of activity and the level of growth in the country. So that's relatively positive. There's also a strong smattering of energy projects and quarrying. So there's a clear focus on enabling and supporting growth and development, especially via major infrastructure and also quarry capacity. Emily, quick look at the details. Housing and land development, that's one major. There's only 5 categories that are identified in the list, but the main focus on housing and land development is on housing, but most of the projects include urban development generally. So it's not just housing, it's commerce and employment and so on. So that's quite a positive component in terms of getting comprehensive or holistic development. And there are some major specific developments, but it doesn't seem to be a wholesale effort to, as it were, solve the housing issues by enabling lots of capacity everywhere. Next, Emily. Yeah, infrastructure, as you may expect, strong emphasis on roading infrastructure, but there's also clear, port infrastructure with our 2 largest ports, and that's quite important for economic growth, and rail infrastructure, and including a multi-regional initiative. So the whole notion of supporting development through infrastructure, I think, seems to be relatively well captured in that mix and distribution. Next one, Emily. Mining and quarrying. That's one category. For whatever reason, I broke that down into mining and quarrying. Quarrying generally related to the major centres, mining more dispersed, and I venture to suggest certainly a lot more controversial in terms of potential environmental effects. Energy is the next one, Emily, and a reasonable coverage there: solar energy, wind energy, hydro energy, and distributed around the region. So there's a mix in the urban economies and in the regions. And the final slide is just aquaculture, 7 aquaculture projects, mostly in the South Island, only 1 in the North Island. So next slide, Emily. So looking back to the issues I posed, it's quite a strong mix of projects, and I see it generally is likely to support economic development and community growth. So I see that as quite a positive. And it's especially if there's appropriate backing for economic development and growth from key large-scale infrastructure. So I'd see it as a sort of a solid, well-spread mix of priority projects and geographical focus in growth areas. So I see, in terms of actually putting the fast tracking on the ground, I see that as generally a positive outcome of what's been proposed so far. Second issue is that the devilish need for speed. Speed is always a risk in terms of the amount of time and resource which you can put in for evaluation. And that's not necessarily different from what it is these days, but you're dealing with the large size of quite a lot of the fast tracking projects. So that really emphasizes the focus which has to go on the quality of decision making. On the other hand, most on the fast track list are major projects which will be spread over a number of years. So that suggests that there is reasonable time to evaluate fairly thoroughly these projects. The third issue, Emily, is the volume of fast tracking development. Will that constrain the assessment time and resource? And again, yes, it's a risk. And it puts a lot of onus on the experience and capability of the evaluators and the final decision makers. So the change that's proposed to put the final decision making away from, if you like, the more political arm towards the more technical arm, I see that as certainly a positive. And also we're dealing with a relatively solid mix of projects on the fast tracking list. So, there's clear opportunity for experience and capability of relatively independent evaluators to make it a reasonably strong or positive decision-making process. Fourth issue, will the focus on fast trackers limit resourcing for other development? Absolutely. It always does risk, and it may not be materially different from the case, not the case is now, but there's also the issue that, that Gina was pointing out about the lack or the scarce resource being suggested for actually paying the people for their expertise and knowledge to support the fast tracking process. And I will leave it there with a minute and a half to spare. Thank you, Emily.
Fantastic. Thank you, presenters. So we do have time for questions and comments, and I'm just going to stop. There it is. Stop sharing my screen so you can see our lovely faces. So Q&A function, if you have questions, there have been some coming through, and I think my fellow panelists have been answering some already. So you can click the answer tab to see what some of those answers have been. So I will have a look at the ones that haven't been answered yet and see what we might be able to do to answer those. And if you have questions, keep kind of adding them in because we've got a good 15 minutes or so. First one that isn't unanswered, got lots of questions in it. I'll make my way through it and we'll see how we go with answers. So the bill now contains the term unlisted projects, and it looks like these can proceed under the fast track umbrella as well. Does this imply there will be future waves? I assume that means more projects coming through. I think that unlisted projects refers to things that are applied for to be referred through the standard referral process, if you like, as opposed to those projects that are included in Schedule 2. So Schedule 2 will have the 149 projects, but then there's the ability for any other project to apply into the fast track process. So there will, it's a permanent piece of legislation. It'll be there for as long as it's there, and projects can keep applying to use it on an ongoing basis. Is that any of the panels think? Yep, nod, cool, that's good. What else have we got there? Are connections to infrastructure services such as Three Waters omitted from the bill? If yes, when do you think these issues would come into play during the process? I assume that's a question related to housing developments, and are connections to infrastructure part of that or not? I think I'm not entirely sure of how to answer that one. The bill doesn't say what you can and can't apply for. It just talks about general benefits that the project have to have. But any other panels want to comment on that one particularly?
I think that's right, Emily. There isn't a significant restriction on the types of projects that can apply to be fast-tracked. So if they have national regional benefits or expected to do so, then they can apply. The issue that's going to arise now is the capacity to actually take more projects, and that is one of the matters that has to be considered in deciding whether further projects should be referred, the impact on the ability of the fast tracking system to function, if you like. And for comparison, the COVID fast tracking legislation, if I've done my numbers correctly, I think it's something like 114 or 116 projects have been considered under that since mid-2020 to when applications closed at the beginning of this year. And it has been a very significant challenge for Judge Newhook, the panel convener, to obtain that number of panels for that number of projects over that time period. And effectively what this bill is setting up is that there's scope to set up 149 panels as soon as the legislation comes into force.
Cool, thanks, Helen. And then the
Emily,
other
I was just going
Sorry.
to add there, if the question, and I'm not quite sure if I'm reading it right as well, if the question was how is a panel going to know if there's infrastructure services provided for a proposal, then I would think that that would come through with comments from the local authority and any relevant government department as well.
Yeah, that's a good point, Gina. So local authorities are one of the parties that has to be given an opportunity to provide comment on applications. So yeah, that's an avenue to raise that. Yeah. Okay, and then the last question on that bunch is related to what the overall timeframe for fast track process might be. And that's it's supposed to be a fast track process, but the answer to that question is how long's a piece of string really? Because there are timeframes in the bill, like 25 working days for a panel to make their determination after comments are received, but that can be extended. There are other kind of participation timeframes that are all quite short. One of the key timeframes missing, which I think Helen mentioned, there's no timeframe for a panel to be appointed. So an application can be made to the EPA, and the next step is that the panel picks up that application and considers it. But if it takes 5 months to get a panel set up, then that's outside of the timeframes in the bill. So we're going to have to see how it actually works out in practice, because I know under the current fast track legislation there are issues with the timeframes that kind of aren't in the bill, and things can still take a while.
And just to add on the timeframes there, one thing that has arisen with the COVID fast tracking process, and indeed with the previous Board of Inquiry call-in process, which was intended to enable large infrastructure projects to be consented at speed as well, is that the applicants need more time during the process to actually respond to matters being raised, do redesigns, that kind of thing. So it has often been the applicants who have needed to put the process on suspension so that they can properly address matters arising.
Okay, next question. Do you think there will be a greater reliance on the use of management plans to address adverse effects rather than more thorough analysis, given the short timeframes available for panels to consider proposals, despite previous Environment Court decisions that warn against such reliance? I guess that's a possibility. Does any of the panel want to comment on that specifically? No, that's cool. We can move on.
I will if I can.
You will? Yeah, sure. Sorry.
Yeah, I think one of the things is, there's been a lot of talk about national standards and getting a set of standards in place so that it's in theory relatively more automatic or automated to evaluate proposals. And I'd see this as an aspect relating to that. At the moment, though, until that is in place, it is going to be, I think, problematic or potentially problematic to assess projects without going into the detail, especially when they're quite major projects. That's all.
Okay,
and
cool.
if I can just add, and in terms of management plans, certainly from my perspective, you need sufficient assessment and basis to know that you can adequately manage effects via management plans. So you need to have that work available to enable the management plan approach. It certainly shouldn't be a process adopted where you go, well, we don't know what the outcomes might be, so let's just put a management plan approach in place and see how things go, especially for some of the larger type of infrastructure that simply doesn't work. You can't put a few significant megawatt wind turbines, for example, in place and see what happens, and can you then go on and continue to build the rest of the wind farm, depending on what happens with those few wind turbines you start with. So there's a few logistical issues there that need to be addressed.
Cool, thank you. The next question is related to a comment Gina made, I think, about competing applications. This one is there also a risk that fast track applications may leapfrog over applications that are going through the traditional process and are reliant on the same resource environmental characteristics, such as discharge permits and water takes? And I think there's a type of it, does it run against the sense of natural justice? I'm not sure if any of us have the answer to that question, but do you want to add to that, Gina?
I think there is a risk. I think it's going to again be one of those significant EPA roles that they'll need to be really keeping in touch with relevant consenting bodies about whether there are any other proposals that are in the system. And to me, it's not really quite clear yet about how to read this bill against existing legislation, particularly in terms of, things like first in, first serve under the RMA. So I think that probably needs to be resolved.
Okay. Yep.
Yeah.
Are you going to add that?
I'd just add in there, I mean, there's an issue or a question about there's no effective triaging system for resource management, and that might be something which could come through in terms of the importance of a proposal. It's the depth or extent of its potential effects, especially negative effects, and the scale of the proposal. Now, the fast tracking partly covers that, but I think there's been quite a bit of comment made about, well, what about the rest of everything? And is there a potential for some sort of triaging system which helps get the rest of everything back into a more manageable order? And at the same time, when we're looking at the changes potentially coming through in the resource management, the potential to reduce the number of projects which need to be evaluated overall. In other words, some of the lesser ones are dealt with more automatically, and don't come on board to effectively or potentially clog the system.
Yeah, those are good comments, Doug. Okay, the next question is about international environmental obligations. What happens when environmental issues take a back seat to economic benefit? Is there a clear inconsistency with international conservation agreements? The Select Committee report actually has a sentence or two related to that, because it was something raised in submissions, and they just say they don't think there's any issue with international obligations. So
yeah. That's right, and indeed, so in response to that issue being raised, the Select Committee, or the majority Select Committee report, says we recommend that the Ministry of Foreign Affairs and Trade and the Ministry for the Environment develop supplementary guidance for the Minister and the expert panel to help them identify relevant international obligations that may apply to consent applications as they consider them. So effectively a kick the can down the road approach.
Yeah, and I would say there's an issue, I suppose, of the philosophical approach here. I mean, I would see the environment includes the economy, or the economy, if you includes the environment. So, the economy is not the business sector. Business sector is part of the economy. The economy is the whole works. So, it's important that the holistic approach is not lost, because I mean, the whole RMA, is based around a holistic approach. And like I said, the economy is not just the business sector.
Okay, the next question is super specific, and I don't know the answer to it because it's about how the MBEA fast track legislation works. But do we need to get both the referral application and the substantive application submitted before the fast track legislation comes into effect, for the application to continue to be processed under the MBEA fast track, or just step one? We don't have to spend much time on this because it's so specific, but does anyone know the answer to that one quickly?
I think I'm right in saying you just need to get the referral. Well, you'd need to get the referral application and be referred. So once you've commenced the process under the MBA fast track, my understanding, at least of the transitional provisions as they came out with the fast track approvals bill, is that once you've commenced under the MBA fast track, you'll be able to complete your process under that legislation, despite the fast track approvals bill progressing and coming into force.
Okay, cool. Thanks, Helen. All right, next one. What is your opinion on having a fast track process in the local, regional and national level that is a well-designed process without the issues discussed here that could benefit the consenting process? One answer to that is that if we get the system right in the first place, we didn't need a fast track process, and that's a point that NZPI made in its submission, that we're going to redo the RMA, so let's do it in a way that means we don't need a separate process. What do the other panel members think about that? Nods.
Certainly agree. Yep.
Okay, that's cool. We've only got a couple of questions left, so there's a minute. We can keep going for a few minutes if other people want to add some in. When do you think traditional consent applications would likely pivot to the fast track process? Are you going through tech assessments now, and another scenario at council hearing declined mediation stage? I think the answer that's probably it depends on lots of different things. Does anyone want to provide an answer to that?
The reality is some projects have already done that. There have been applications that have even stopped mid-hearing once they realised the bill was introduced and have had confirmation that they've been included in Schedule 2 for that. There's already at least a handful of projects that have stopped proceeding under the normal consenting pathways and are opting to take their hand under the fast track process instead.
Okay, and one more on the list at the moment. Can you please expand on your concerns around projects that require reconsenting, applying for fast track consenting instead?
It wasn't that quite what I said. It was more I was concerned about what happens when there are projects going for reconsenting. You know, they are relying on an existing resource as it is, and then somebody applies for a consent for the same resource under the fast track system. So that's more my concern.
Yeah. All right, another one got in quickly. What happens if an application has been called in as a project of national significance and is now on the fast track list? Well, I guess if it's on the fast track list, it's going to go through a fast track process.
It could go through both, and it might end up with two different answers. Who knows?
And depending on the project, it may well do so. To reiterate the point, there are a number of great projects, I think, on the list of 149 projects, which are worthy of a consent. And I think for all those projects, they generally aren't going to need a fast track process, that they would have no issue getting in under the normal consenting process. So, there's lots of things to consider with this. As far as I'm aware, there's no projects at the moment that are in that situation of having a call-in decision made for them, and now also being able to go via the fast track consenting process. But if there was, it would be their call as to which consenting process they wish to pursue, as I understand it.
Cool, and we don't have any other extra questions. There's some nice comments. Thank you, people, for making nice comments. So I might wrap up. It's 2 minutes past 1. Thank you, everybody, for listening in, and thank you to my fellow panelists for providing your points of view and expert opinions on this topic. It's definitely going to keep us busy for a while yet, I would say. So thank you, everyone. I'll end the presentation. Ka kite.